On October 29th, 1958, 13 police officers, including Frank Pape, arrived at James Monroe's Chicago apartment at 5:45 a.m. The officers broke down the door, forced Monroe and his wife to stand naked in their living room, and ransacked the apartment. Afterwards, James Monroe was escorted to police headquarters and held for 10 hours on quote-unquote open charges while he was interrogated about a murder. The police did not have a warrant for the search or the arrest and refused Monroe permission to call his attorney. Monroe brought a complaint against each of the Chicago police officers individually and against the city of Chicago. The city of Chicago moved to dismiss the complaint on the ground that it was not liable under the Civil Rights Act nor for acts committed in performance of governmental functions. All defendants moved to dismiss, arguing that there was no cause of action under the Civil Rights Act. The district court dismissed the complaint. The United States Court of Appeals for the Seventh Circuit affirmed that district court's dismissal. So there's two legal questions that the court is deciding in this case. The first is, does a person have a valid cause of action under the Civil Rights Act against police officers when the police officers violate that person's due process rights? And then the second is, can municipalities be liable or held liable under the Civil Rights Act? So the court decided this case, it stated that the city police officers, in conducting an unreasonable search and seizure, had committed an action which was under the color of law, and that the police could be held liable individually under the Civil Rights Act. However, the majority further held that a municipality could not be liable under the Civil Rights Act. So the court reversed the lower court's opinion insofar as it dismissed the Civil Rights Act claim against the individual officers.